When she arrived at the car park, she parked the car and then went to the ticket machine, took a ticket for her parking. She paid for it. When she'd finished her meal with her friends, she drove home and thought no more of it. Until a couple of weeks later, she received a PCN through the post.
What it transpires is, I eventually found out, is that the ticket only displays the first 4 digits of my registration. And they are saying that that invalidates my ticket and that I'm in breach of their terms and conditions. And I didn't notice that at the time. You pay, you get your ticket and you pop it in your car and you don't actually examine it that thoroughly. And it wasn't until the charge notice came and I checked the ticket and I thought, oh gosh, yes, there is only 4 digits. And yet the picture of my car that they show on the parking charge notice shows my number plate clearly and show that the 4 digits correspond with that photograph. I sent them a blown up copy of the ticket plus a letter explaining that, yes, I had bought one and here was the proof. And I thought that would be it. I thought there's the proof. They're going to believe this. Why shouldn't they? The proof is there. And then I got another letter saying that my appeal had been denied. No valid pay and display permit was purchased, like they keep repeating themselves like a broken record.
Well, I said to Annette, let me go and have a word with the private parking company. As regular listeners to this programme will know, it all depends on which company it is as to whether or not we ever have any success with these kinds of cases, because a lot of private parking companies just simply don't respond to us. They don't engage. They have no interest in communicating with us. Now, when I saw the name of the company that was pursuing Annette, I have to be honest with you, my heart sank. Because over the years, I don't believe I've ever managed to communicate with this company about any of the issues we've investigated at all. And I'm afraid to say they've been true to their previous form, because I've had no response to Annette's complaint, where I have tried to suggest to them that there is evidence in the form of that ticket that Annette did buy a ticket on that day. Admittedly, it doesn't have the full number plate on, but there is a ticket that shows she did pay on that day at that time that they're accusing her of not having paid for her parking. So do they really feel that it's fair and reasonable to pursue her? As I say, no response whatsoever. Now, in the meantime, I then received a phone call from Michael, who recognised the story that Annette had told and said, I think I've had exactly the same experience in exactly the same car park. Except when Michael put his number plate in, he says that only 2 digits from his number plate were then printed on the ticket. And he says that Euro Carparks have been pursuing him for the last few years regarding that particular day and that particular parking incident. And they've now escalated things to the small claims court, and he's now received notification that they have begun court action against him. So it's all a bit of a mess. Well, Annette and Michael are on the JVS show now. Hello to you, Annette. Good morning.
Hi there. Good morning, Jonathan.
And good morning to you, Michael.
Good morning, Jonathan.
Now, what is so very strange is you both say that you put your full number plate into the machine on that day that you parked your car. But you say the machine only printed part of your number plate on the ticket. So, I asked you, Annette, the other day, could you please go back to the car park and could you film yourself trying to buy another ticket for your car, put your full number plate into the machine, and let's see what it prints on the ticket. So you did that to start with, and it printed the full number plate of your car on the ticket, didn't it?
It did, that's correct, yes.
So then you tried again, and this time you just put the first 4 digits of your number plate in and then tried to go through with the process of buying the ticket. Now, much to my surprise, because you would imagine that the machine, if it requires you to put your full number plate in, you would imagine that it won't allow you to actually go through the process of buying the ticket until you've put your full number plate in. But after you just put 4 digits in and pressed the green button, it printed a ticket showing just the first 4 digits of your number plate.
It certainly did, yeah.
So I have to be honest, when I saw that evidence, my heart did sink rather, because I was thinking, oh dear, Well, that doesn't necessarily help your case, because could it be argued that this machine does allow someone to just put a little bit of their number plate in, and if the parking company says you have to put the full number plate in, could they ultimately make the argument that you've broken the terms and conditions of the car park, you haven't put your full number plate in, and therefore they are within their rights to pursue you? Well, I wanted to get the legal answer to what is going on here and what, if anything, can be done. I knew just the man to go to. Nick Freeman, the lawyer known to all of us as Mr. Loophole, is on the line now. Hello, Nick. Good morning. Thanks for coming on.
Good morning, Jonathan. Good morning, Annette. And good morning, Michael.
Right.
Good morning.
So what do you reckon,
Jonathan,
then?
Well, Jonathan, I think you've nailed it beautifully. One of the conditions is that you purchase a valid ticket. And I think it's important to recognise that these machines have to cater for lots of different number plates. So some people have 2 letters in a number plate, some people have 3, 4, DVLA supply, all sorts of different numbers. So to purchase a valid ticket in compliance with their conditions, you have to put in the full correct number plate of the vehicle that is parked there. And I think what's not in dispute here is that in both cases, Annette's and Michael's, there was an inadequate number of digits and letters on both tickets, which renders them invalid, and that renders it a breach of their terms and conditions. So that is their argument, and there's no dispute about any of that quite clearly. And I'm not suggesting it's human error. It might be, we don't know. But without some concrete evidence that the machine was defective, I think that the court would assume, or certainly people will assume, Euro Carparks will assume that it's as a consequence of a human mistake, and it's a sort of mistake that people make on a regular basis. So I think one thing that can be gleaned from this is, whenever you're using these types of machines, make sure you put in correctly all the digits and letters. Or even better, download one of the apps. So it's all done, and it's a very simple process to follow. I'm bound to say even I can do it, and it just makes life so much more easy once you download it. That's probably the way to go forward. Dealing with these particular cases, all is not lost. There was actually a case on this in 2015. It's a well-known case called Beavis against Magic Eye. And what it concerned itself with was the charges that are claimed by way of the PCN. Does that recognize the true amount of the loss? And in both your cases, Michael's and Annette, you've paid in full. And what we're talking about is a minor clerical error, an administrative error, where for some reason the number plate's not been fully put into the machine, but you've paid. And that means there is absolutely no loss, no financial loss to the company, save for this. When they have a problem such as this, there is a small amount of cost incurred on an administrative basis, because the ticket shows actually this isn't the correct car. So there inevitably will be some cost incurred for dealing with the mistake that's being made. And this is a sort of grey area. That mistake doesn't equate to anything like £60 to £100. Now, what you could do, and what I suggest you do, and I know you've been to Poplar, and can I say that Poplar inevitably sides with strict compliance with the conditions. It looks at the conditions, you breach the conditions, we find in favour of the car park company. That is invariably what they will do, unless there's, amazing mitigation, I couldn't comply because I was having a heart attack or something really serious, and you still then need to furnish medical evidence. And I'm not suggesting anyone says that. So that's normally what Poplar does, but that's not an end to the story. What I suggest you do is you write back, both of you, and point out that, in fact, you have paid in full, and there is, in fact, no loss sustained whatsoever, except for an administrative charge, which you recognise. And I would suggest that you donate a cheque of something between £10 and £20, and that's just the amount that I feel recognises the amount of administrative charge reflected in the extra work that they've had to undertake to deal with the human error, or the lack of number plate. Let's just call it that. That's what I suggest you do. I would also write back in the letter and say, look, Beavis, this is this 2015 case, BEAVIS, It's a well-reported case. I'm sure you can Google it and read about it. You might find it quite interesting. We rely on this case because what it eventually...
Did you say, sorry to interrupt you, Nick, was that Bevis versus Parking Eye, did you say?
Yes, I did. It's 2015.
Okay.
And what it says, I mean, I can give you a little bit of Latin, but what it really means is that the Latin is de minimis non curat lex. And what that means is the law doesn't concern itself with triviality. So in other words, in criminal law, and this isn't criminal, this is civil, but when the mistake is so minor, then we just ignore it. And that's in effect what's happened here. Basically, someone's made a mistake. We don't know who. It might be you, it might not be you, but you've paid in full. There's no loss. Here's a little bit of extra money to deal with it, and make it clear you do not intend to pursue this further. You do not intend to pay the outstanding amount. Now, the matter then is up to them. They can decide, actually, this person seems to know what they're talking about. They've actually given us a sum of money which reflects the administrative costs incurred. I would suggest £20. I'd go over rather than under, so they can't say, well, that cost wasn't a fair amount, and see what they do. There is, of course, a risk. It's a gamble because, as in Michael's case, and they've already started, in Michael's case, they've already started county court proceedings. And what I would do, Michael, is I'd write the letter as I've suggested and give them £20 and see if that gets rid of it. It might do and it might not. But the risk in going to the county court or letting them pursue you in the county court is you might lose. If you do lose, there will be more costs incurred. There will be legal costs incurred. It's the sort of thing you can defend yourself very easily. You don't need a lawyer, but they will inevitably have a lawyer. The judge probably will be very sympathetic to you and think that you've been perfectly reasonable. You may have made a mistake, but you've more than compensated them for the mistake you've made. But there is a problem in that if you do lose, it could affect your credit score. Now, I don't know whether that's significant to you or not. So you're undertaking a gamble, and I can't advise you whether or not you feel that gamble's worth undertaking. I think it depends on your own personal circumstances, how strongly you feel about it. I certainly would write the letter and give them the money and see how they react to that, and then you need to take a view.
What happens, Nick, if they then argue that they've now instructed debt collectors, which has then meant that they've incurred a further charge? Would that be something that they could legitimately argue you also owe them for?
Well, they won't instruct debt collectors until the county court has issued a judgment.
Well, they already have, but because you, Annette, I gather, received a letter yesterday from a firm of debt collectors.
I did indeed. Now they want £170.
Without a county court judgment.
Absolutely.
Are you sure that they've not been to the county court yet?
No, they haven't mentioned any of that. No, I've just received this debt collector's letter. It's from Debt Recovery Plus.
Yeah.
I got the same letter like on the beginning of my case, like after a month. That was probably the first letter what I got from them as well.
What they're doing, I'm afraid, is using bully boy tactics to frighten you into paying.
Yeah,
that's what's happening. Because the court needs to make a judgment. It needs to go through a court. Poplar's made a decision, but you then need to write and say, right, I'm not paying. You need to take me to the county court and see whether they do. And if they do, then you can take a view. Or you just say, look, I don't want the stress. I don't want the aggravation. I'm going to pay it now, get rid of it. And in future, make sure I just get it right. And that's your call. And it is a very stressful situation because you will be getting letters on a regular basis saying you owe this, the costs will rise, and they're bully boy tactics.
Well, it just seems so unfair when someone has got evidence to show that they did pay to park their car. And it may well be that there's a technicality with the ticket, but they both have got tickets that were valid for the duration that their car was in the car park on the days that they're being accused of not paying for the parking, it just seems so unfair.
It is completely unfair. But trying to play the devil's advocate and look at their position, that they have to check all the cars that are there with the correct number, etc., etc. It's clearly stipulated there must be a valid ticket. And in both the cases we're talking about, that there is a breach because the ticket's invalid because there's a paucity of information. So the onus is on the driver or the person who parks the car to make sure they have a valid ticket.
Okay.
And yes, there's a breach. It's a technical breach, and it is unfair, and you can fight it out. You've got to decide whether you want that stress, that aggravation that could go on for a long time, or whether you could just get rid of it and learn a lesson, and all your listeners learn a lesson. Get the app in future, and just you press a few buttons and it's paid and it's done, and you just don't have any aggravation.
In terms,
I can't make the choice for you, I'm afraid.
No, and we understand that. And in terms of the two, both Annette and Michael, they're obviously in slightly different situations. So in terms of Annette, get on, write the letter, enclose a cheque for £20, say that this you hope is going to be an end to it, and you can both move on and you won't hear anything further, and see what happens. That's understood. What about Michael though? Because they've begun the small claims court action, and he's, I gather, got until next week in order to provide some kind of defence to the court. What does he do?
Well, he's fine. So he goes to court. That's fine, isn't it? He goes to court. He either settles it before court, which is an option to him. But as they're taking him to court, he goes to court. He takes complete proof that he's paid the ticket, that he made this completely clear to them. He's happy to pay them a small amount for any administrative charges that they've incurred, and he should probably write this beforehand. I would suggest, as I've said, I'd do the same letter, Michael, as I suggested to Annette. It applies to both of you. Say, you're happy to pay for the administrative charges. As far as you were concerned, you put in the correct number. This is the number that came out. You've obviously paid your money. You paid. There's no financial loss. The law doesn't concern itself with triviality. There is no loss. I've paid. Why are you taking me to court? Here's £20 for your administrative costs. And otherwise, I'll see you in court and have your day in court. I think, Michael, you're really committed to it now. You're almost too far down the line. And, my advice is I'd prepare it and go along with all your ducks lined up and fight it. Bearing in mind, judges tend to be sympathetic to motorists who, but really from a moral standpoint and largely from a legal standpoint, are completely innocent. You've not tried to pull the wool over anyone's eyes. There's just been a mistake made. And I imagine you'd say, as far as I was concerned, I put in the correct digits. I can't say whether the machine was working or not. All I can say is that I know my number plate, and this is what I did. In Annette's case, can I just make this point, Annette? There does seem to be some uncertainty when you play the video about your number. So I wouldn't be encouraging you to play that video. If you
No, I did. It wasn't quite.
You didn't quite convince me.
No, the video, Annette, was not quite the video I was hoping for. I'll be honest with you. I held my head in my hands as I watched it yesterday.
I just, obviously, I'm sure without the video you'd have known your number. But, when the camera's on, you've got a bit of camera scare. I wouldn't be volunteering that as an exhibit to support your case, because I think
it was just a senior moment, a brief senior moment.
Yeah, but the problem is,
we all have that.
But the problem is, as Nick says, if you have a senior moment, the company can use that against you and say, well, how do you know you didn't have a senior moment on that day and only put the first 4 digits of your number plate in?
But the mischief that we're talking about here is that they're saying to you, look, you enter our car park, there's a cost incurred. And that's exactly what's happened. You've entered the car park, you've agreed their terms and conditions, there's been a slight breach, but they haven't sustained any significant loss, certainly not a £60 to £100 loss. And that's the point, isn't it? It's not as if you're a criminal trying to get away with something. And those sort of arguments are often met favourably by a county court judge who'll say, look, this lady's been perfectly reasonable, as has Michael. They've even offered to pay your admin charges. And Michael, I do yours straight away. When this call is ended, I both of you get a letter off straight away, send it by registered post, recorded delivery, and see where you go, and then take a view.
Sure.
But be aware of the pitfalls. I think, Michael, you're too far down now, and you might as well go with it. And I'm sure if you win, And if you get your case properly prepared, I'd take your V5. Is your car registered in your name?
Yes, exactly.
Yep, so I'd have your V5, I'd have the copies of the tickets, everything you can do to illustrate you've paid there, copies of all correspondence, and also a copy of the fact that you've actually offered and paid £20 to cover their administrative charges.
Yeah.
The problem you have, Michael, now is they will have already incurred some charge, some costs in going to court. There will be a fee for going to court, and my advice is, look, the fee incurred is because we're arguing that they're trying to enforce something that's of such a trivial nature they shouldn't be enforcing it, and therefore they wouldn't have incurred it. So I just offer the £20 and go with it and see what happens and report back to Jonathan. And if Jonathan wants to come back to me, then we can do that. But there are risks involved. It's at an earlier stage, which is much better. But they can only enforce this payment. You know, these letters you get are scary letters, but the reason they've taken you to the county court, how many years afterwards is it, Michael?
It's exactly 2 years over.
Yeah. And have you had any bailiffs round before then?
No, never.
No. They're bully boy tactics, and they're deplorable, absolutely deplorable. And both of you should make it clear that you've been threatened with bailiffs, which is very scary, isn't it? Because it makes you feel very uneasy about your home, which is your place of safety. And I'd make, that this practice needs to be banned, and it's deplorable on behalf of Euro Carparks that it's a massive, very wealthy company that they're still pursuing this really shoddy treatment of people who are largely innocent to try and scaremonger them into handing over their cash.
Well, as I say, I'd love to be able to present a response from Euro Carparks on the programme, but I can't because they haven't responded to any of our emails. Nick, as always, thank you so much for your time. You're a busy man and you've made time for my listeners, so thank you very much indeed. Nick Freeman, the lawyer known as Mr. Loophole. Right,